Okay, welcome to session 18 of Creditors in Commerce Living Temple Classroom Sessions. Interesting thing, the number 18. Anyone know what it, as far...
Slavery. Title 18?
No. Interesting about Title 18 too. What's Title 18? Criminal Code. So it's where all the crimes are listed? And well, if you guys stop talking, you might be able to hear me. Because I'm hearing more of you than I hear of myself. Okay. So the number 18 also symbolizes what? Anyone know the biblical numerology of number 18? Slavery. Okay. I was going to bring you a big stack of documents tonight. Processes and procedures. But I didn't want to be an enabler. No. Listen to me. You guys think that the documents are your remedy. And it's not. There are no documents that are going to bring you any remedy. There's no magic documents. There are no magic phrases that are going to bring you a remedy. You may hear Gordon say something or me say something and you want to jot it down like, oh, that's the magical phrase. That's what Gordon said to get what he got. No, it has nothing to do with the words Gordon uses. It has everything to do with who Gordon is and who he's being. So, let's talk about why we might get tested. Because a person can respond, does that make them a critically thinking human being? No. I can teach a parrot to respond. And every time you try to memorize phrases as this is going to be my response, well, you're just acting like an animal, and that's when the test comes in. Because any parrot can be taught to respond a certain way to certain things. It doesn't mean the parrot has the capacity to critically think or bring a solution to anything. So the nature of the test is to see, are you an animal? Because that's why you get treated like an animal. Are you a creator, creditor? So there are no magic phrases. It's in who you're being. Now, as far as getting your remedy, when you're in any situation where a claim is being made against you, the true power is in turning the claim upon the claimant. And what I mean is, there has never been a claim made in the public on you that had anything of substance behind it. So when you go in arguing and fighting it, you're giving it merit, but you haven't brought a solution. Rather than argue and fight it, turn it around and put the burden of bringing substance to that claim on the party making the claim. I brought an actual sample of not a sample, this is an actual court case I'm going to be appearing on. I want to give you an idea of the kinds of things that are going on in there and why the simple conditional acceptance, confession and avoidance, two very simple concepts that, and again, it's not something to memorize. You're not going to memorize a series of questions. It's about knowing who you are, and when you're faced with a claim, accepting it and flipping it around in such a way that you've now put the burden of some kind of proof or to bringing some kind of substance to that claim on the person making it. Now, what you'll see in this document, and they've got evidence attached and everything, and this is an unlawful detainer, which has to do with possession of property. And what I'm going to show you is there's absolutely nothing of substance in this at all. And how, without one piece of paperwork, you could walk into a court and make this go away. Because it has nothing to do with the paperwork. There is no magic paperwork. It has to do with who you are and knowing what this is. Everything's contract, right? So it's an offer. And any declarations, unverified declarations, they don't stand as evidence anywhere. Does anyone know the meaning of the word verified in terms of law? Or how about a verification? To make true. Well, there we go with truth again. Truth is all in the experience, but we can establish facts. Okay? Here's what Black's Law has to say about verification. A formal declaration made in the presence of an authorized officer, such as a notary public, or under oath, but not in the presence of such an officer, whereby one swears to the truth of the statements in the document. An oath or affirmation that an authorized officer administers to a defiant or deponent. Now, what I want you to notice is that I think there's maybe one area in here where the attorney declares under penalties of perjury something. I want you to pay very close attention to what he's declaring, or what he swears to under penalties of perjury. Okay, so basically it's a complaint, series of points, not a sworn or verified statement, just signed at the end. Here's what we're alleging. Okay? What's an allegation? As far as I'm concerned, it's just a statement. Has no meaning, has no substance. Okay. So, actually, this one does have a verification attached, so we'll go through this. Plaintiff, some corporation, is a Delaware company duly authorized to conduct business in the state of California, with capacity to sue herein, is entitled to the possession of and is the recorded owner of a parcel of real property and the dwelling thereon located at 2216, some street, some city, County of Los Angeles, State of California, and a zip code. Said property is located within the above captioned judicial district and county. Number 2, the true names and capacities, whether individual, corporate, associate, or otherwise, of the defendants named herein as Does 1 through 10, oh no, inclusive, are unknown to plaintiff, who therefore sues said defendants by such fictitious names. Plaintiff will amend this complaint to show their true names and capacities when they have been ascertained. Number 3, that defendants in each of them are currently in possession and occupying the above described premises, that plaintiff purchased the above described real property at the trustee's sale held on such and such a date in accordance with California Civil Code section 2924 under a power of sale contained in the deed of trust in its title and has been duly perfected. Now that's an interesting statement that they made right there, that they purchased the property. Because when you go, they've got on here an attachment. That attachment is the trustee's deed. Okay? The trustee's deed says no such thing, that any property was sold to anyone. And we'll go through that and see what it actually says. So again, That's not true. By their own evidence, that statement there is not true. Number 5, the plaintiff has a duly executed trustee's deed upon sale, a copy of which is attached hereto as Exhibit 1, and by this reference incorporated herein as it is set forth in full. There you go. They're bringing their evidence showing that they bought the property. That on or about April 24th, plaintiff, by written notice, made demand of said defendants for and required delivery of possession of said real property with 3-day notice. Okay? And written notice, said defendants, reasonable value. Okay. It was performed. Yeah, nothing really interesting on that. Okay. So, this is the verification. I, so-and-so, am the attorney for Nation Star, some corporation, the plaintiff in this action. Such party is absent from the aforesaid county where such attorney has his office, and I make this verification for and on behalf of the party for that reason. I have read the foregoing document and know its contents. I am informed and believe, and on the ground allege, that the matters stated therein are true. Executed this day, wherever, I declare, under, and then, next paragraph, I declare under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. That he basically, I promise that I think so. Right? He's swearing that, hey, I promise, those are allegations. I promise there is nothing of substance backing up my claim. That's what he's saying. I swear I have nothing backing up my claim. Okay, so, good to know. Okay, trustee's deed. The undersigned grantor declares. The grantee herein was the foreclosing beneficiary. The amount of unpaid debt together with costs is such and such amount of dollars. The amount paid by the grantee at the trustee's sale was such and such dollars. The documentary transfer tax is $0. Okay. So-and-so company, this is the trustee, a California corporation as the duly appointed trustee under deed of trust, hereinafter described, herein called trustee, hereby grants and conveys, but without warranty, express or implied to this bank that was the actual seller and the buyer, herein called grantee. So, a trustee who never had any interest or rights to the property has now granted something to the bank. The bank in this statement is a grantee, the trustee, the grantor. What does the trustee in any deed of trust have the right to grant and convey? Nothing. No, that's not true. The lender's interest in the property. For instance, you have a credit card debt, okay? And your credit card closes your account and they sell the debt to another company. That's what happened, except they sold the debt to themselves at a discount. What would that ledger entry look like? Basically, they would take this asset, a debt, and discount it. It's not worth as much as it was. That's all that happened. They adjusted their ledger to show that an asset, this account receivable, is not worth as much as it was before. That's what happened. No property was sold. So, such and such company herein called grantee, okay, now remember, the grantor hereby grants and conveys, but without warranty, to the corporation that was the seller in the first place, herein called grantee, all of its right, title, and interest. What right, title, and interest does the trustee have in a property? None. Okay, so there you go. He's granting and conveying his interest as trustee, which is none, to this grantee, who was actually the original lender, at a discount again.
That would make the title company.
What's that?
Wouldn't that put the title company?
Title company has nothing to do with this. No.
Okay.
Now they may give a copy to the title company and say, hey, look, we own it. And the title company might go, oh, okay, yeah, it makes sense to me. Let's go to the end of the trust deed. Is Clark in here? No? Okay. Does anyone know the difference between a jurat and an acknowledgement? The notary.
Jurat is a sworn statement.
Right. What's an acknowledgement?
It's just you're acknowledging your signature.
Just saying that this person actually signed the document. Okay. Remember last week I gave you a sample of an affidavit. And the affidavit had a jurat because it's a sworn statement. One of the students in this class took that and replaced it with an acknowledgement. What did he do to his affidavit? It's not a sworn statement anymore. Now, all the notary verified was, yep, he signed it, which is just like this trust deed. The person signing this trust deed, do they have any firsthand knowledge that a property was sold? No, they're just doing their job. Yeah, trustee sale officer, yeah, sure, that's what happened, I guess. And then what happens? The notary comes in and says, yep, that's the guy who signed it. Again, no declarations under penalty of perjury, no verified statement, just an unsubstantiated declaration, which, if you read it carefully, they're not saying they ever sold the property. So it's not that they're directly lying about it. They don't even know what they're saying in this document, because this is a template. This is a template that they pull off the computer, they put the names where they go, and they spit it out. They don't realize what they're actually doing. These people aren't against you. They're just doing their jobs. They don't know what's going on, no more than most of you don't know what's going on. Okay, so unsubstantiated claims. Exhibit there, proof of service. Oh, wait, I think this is the only thing, might be. Oh, okay, here we go. The first document under penalty of perjury. We mailed this to the defendants. That's the only thing they've sworn to yet, is that they mailed it to the defendants. Sweet. A notice to quit. This is one of their exhibits. This would have been probably pinned. Actually, I know the people in this case, they never even got this notice. It was never put on their door. It was never mailed to them. They never received this notice. Actually, it may have been mailed. I don't know. I can't testify whether or not it was mailed. I just know that they didn't receive it. Notice is hereby given that within 3 days after service on you this notice, in the event you are the original trustor or successor trustor of the property, or within 60 days after service on you of this notice, in the event you are an occupant of the property and not one of the owners of the property, you are required to quit and deliver up possession of the above stated premises to the undersigned, who is authorized to receive the same, or the undersigned will institute legal proceedings against you to recover possession of said premises and for rents or damages as provided by law. You are required to quit and deliver up possession of said premises for the reason that they were duly sold, right, to so-and-so, this corporation, who was the seller and the buyer, in accordance with Section 2924 Civil Code, State of California, on such and such a date, under the power of sale contained in the deed of trust encumbering the property, title under sale has been duly perfected. This notice to you is given pursuant to the provisions of the Code of Civil Procedure, blah, blah, blah. Again, just a signature. No declarations under penalty of perjury, no affidavits, just an offer. That's it. Not one claim in this document, except I like the first one, where he swears that he made allegations. That's my favorite. Because most people would probably see that and think that he was attesting to the veracity of the claims made. These enumerated points, but he wasn't. He swore that they were allegations. Allegations do not qualify as verified statements. Okay. So, how might I approach this? Without paperwork. Could I not walk into the court, say, Your Honor, I accept their offer for releasing possession of the property, upon the condition that they provide a proof of their claim that they have right to the possession of that property. Proof of claim being in the form of a sworn statement under penalties of perjury that they had standing and a superior interest to the defendants to that property. Will they do it? Can they do it? Can Nation Star... Oh. Cat's out of the bag. Can Bank ABC swear to anything? Why not? It's a corporation. Have you ever seen a corporation walk into the courtroom? Your Honor, I want to see the real party in interest. Show me Bank ABC. Have them come in and make their claim. Have them swear under penalties of perjury that they have a superior interest to this property than I do. Now, there may be, now don't get caught up in the words that I'm using because it's not the words. I'm going in there, am I making any positive statements? No. I'm putting it on them to make some positive statements. Remember last week I gave you an example of an affidavit of negative averment. I met with the gentleman this week, turned it into an affidavit of averment. Missed the whole point. Okay? You're putting it with an affidavit of negative averment. You're not making any positive statements. You're making negative statements that leave it for them to make the positive statements. That's why it always, in that particular example, there is no evidence of whatever, and affiant believes no such evidence exists. You're leaving it to them. Bring some evidence, bring some testimony to prove otherwise on this point. I'm going to go another definition here, an averment, so we could get it into our heads what negative averment is. Averment, a positive declaration or affirmation of fact, especially an assertion or allegation in a pleading, a positive statement, to assert formally as fact. Does an averment mean a truth? Not necessarily. It says right in here, or allegation. Negative averment. An averment that is negative in form, but affirmative in substance, and that must be proved by the alleging party. Number 2, a negative statement or allegation, as in a pleading, that constitutes a statement of fact and that must be proved by the party making it. Does that make sense? I'll read it again. Negative averment. An averment that is, now what was an averment? Positive declaration. Okay? So, an averment that is negative. So it's a negative declaration, like there is no, or I'll give you an example that's outside of this. The party was not old enough to sign the contract, or the party was not over the age of 18. What's that do? That puts it on the opposing party to prove they were over 18. Okay, here's an interesting word. Proof. The establishment or refutation of an alleged fact by evidence. The persuasive effect of evidence in the mind of a fact finder. Number 2, evidence that determines the judgment of a court. And number 3, an attested document that constitutes legal evidence. An attested document. Attest. That made sense, kind of leads right into it. What's an attested document? Well, let's look up the word attest. To bear witness, testify. Number 2, to affirm to be true or genuine. To authenticate by signing as a witness. And then we already went through verification. Verify, to confirm or substantiate by oath or affidavit. So when you're asking for a verified claim, you're asking for them to confirm or substantiate by oath or affidavit. To swear to the truth of. Okay, so they allege that they had standing to sell the property. So I could go in there and argue and say, no, they didn't. I'm the trustee on that property. I fired them. Or, I accept that, Your Honor. Condition upon proof of claim in the form of an affidavit or a proof upon, or condition upon proof of claim in a verified claim or by a verified statement under penalties of perjury that they had standing or had a superior or paramount interest to the property. Again, don't get mystified by the words. It's not the words. What am I doing? I'm just saying, hey, they made all these allegations. Yeah, have them bring some proof. Is the documents they bring in proof? No, because the documents aren't attested to either. They had a deed upon trustee sale where the grantor, the trustee who had no interest in the property, grants and conveys the former lender's interest in the property to the new buyer, which is the same company. And again, not signed to. Let's assume it was sworn to. It's still not saying anything. It's still saying granted and conveyed an interest that they had the power to grant and convey. You have the interest in the property. Who's on the grant deed? You are. No banks appear on the grant deed. You appear on the grant deed. You have the interest in the property. They have a debt. They sold their debt. That's all that happened. Did they have a right to? Sure, they could sell their debt. But don't let them confuse you and make you believe that the debt is the house. Are the debt and the house the same thing? No. So, don't go in there and argue with them. Just say, hey, just know what's actually going on. What's actually going on is, okay, these guys sold a debt, but I'm not going to go in there and make positive statements. I'm not going to go in there and go, Your Honor, they just sold their debt. What did I do? I just made an empty declaration. What makes my declarations any better than their declarations? It's unsubstantiated. So rather than going in there, see, when you argue or here's the problem. We want to be right, and we want them to be wrong. And in order to be right, we got to say the things that are going to make us right. But I'm saying, be okay with being wrong. Accept it. Just turn it around on them and have them bring some form of evidence or claim. Have them substantiate what they're saying, because there's nothing of substance in their complaint. And where's the true test? In the oral hearing. I could put together, and I've done it, I put together answers that completely pull apart their claim. Point by point, every single false statement they made, I brought evidence to prove it was false. Did I win? No, I didn't. What was I doing? Arguing the facts. All I had to do was accept their position. Hey, I honor you. I accept your position. All I need from you is some kind of verification. You know, if it's true that you had standing and a superior interest to this property than me, then I'm more than willing to give up this property. However, I don't believe you did. So why don't you bring some evidence? You see, you're not making the positive statements. You don't have to be right. They don't have to be wrong. You're allowing them the space and the opening to be right. Come on, come in and be right. Prove your claim. That's where the real power is. Not in making positive statements, not in arguing, not in saying, look, I've got all this evidence and facts which rebuts yours. Boom! Because I can tell you, that ain't going to win it. I've seen it. I had a stack of evidence like this. Rebutted every single point on their unsubstantiated declaration. And all I had to do was ask them, okay, I accept your position. Bring a proof of claim. Bring something to back up what you're saying. Because all I see here is a bunch of unsubstantiated statements, unverified declarations. And that's probably a lot harder than it sounds, because our natural tendency is to fight. Our natural tendency is to want to be right. Like, oh, how dare they say these things? Let them say whatever they're going to say. Accept it. It's all about where you're at in your heart. That's where your remedy comes from. Your enemy is your remedy. How? Because they're the ones making the statements. Just welcome them in and have them bring some kind of substantial proof, something of substance to back their statements. So, this guy over here calls me a jerk. Does that make me a jerk? That may be his truth. His experience of me is that I'm a jerk. Now, if I go in, I say, well, I'm not a jerk. What have I done? Now I'm arguing. And now I'm acting like a jerk. I'm giving merit to his claim. And do you see why argument, you give merit to other people's claim by coming in and arguing anything? This guy just doesn't want to admit it. So now you're making the statements. You have to bring the evidence. And again, you can bring all the evidence you want, just like they brought all their evidence. The evidence did not substantiate the claim. Public records especially public records that are unsubstantiated, unverified declarations, mean nothing. So what? So you can walk to the county recorder and record a bunch of lies. Good for you. Doesn't make them true because the county recorder recorded them. Okay, that's not how the world works, guys. Just because somebody records it doesn't make it true. Okay, now, There's one other point I wanted to make about handling yourself in any interactions you have with anyone. Okay? So we know now that we can accept, we don't have to be right, and we can let people bring their substance behind their claim. Another way to approach something, let's say, now, see, this works a little differently. If somebody's trying to get you to admit something that may, quote unquote, incriminate you. Okay? For instance, I had a DA investigator come over to my house. He had a promissory note in his hand. He held it up. Said, "Is that your signature?" I said, "Is there a defect in that instrument? Does anyone know what that is?" Confession and avoidance. Let's see what Black's Law has to say about confession and avoidance. A plea in which a defendant admits allegations but pleads additional facts that deprive the admitted facts of an adverse legal effect. How did I do that? I passively acquiesce. I asked a question that he couldn't answer. Is there a defect in that instrument? If he cannot substantiate a defect in the instrument, well, then I can assume that there is no defect in the instrument. If there is no defect in the instrument, what matter if it's my signature on it? You see? Just a question. So I could have said, "Well, I accept condition upon proof of claim that you can ask me if that's my signature." Not really the same thing. So, and again, these aren't tricks to memorize. You could have said a million things to that question. The trick, or get away from that word, the key is to be okay in your heart. Know that if you ever are dealing with anyone, that whatever they say, whatever they allege, it's not about you. It's about them. Let them get all excited about whatever they're getting excited about. Accept that. But don't make up anything else about it. Just like the guy who calls me a jerk. I can get mad, I'm not a jerk. And I can fight it, and I can argue it, and get pissed off about it, or I can just accept it. Say, okay. What makes you think I'm a jerk? That is a conditional acceptance. See how I didn't have to use the word, I accept conditional upon proof of claim? I just asked the question, what makes you think I'm a jerk? That's a conditional acceptance. Or it could be a confession and avoidance. Okay, I'm a jerk. But I've taken away any illegal effect of me being a jerk, right? Because I asked a question. If he doesn't answer the question, then there's no effect of me being a jerk. You have anything you want to say? About? Yeah.
I think I could add a little.
I'm sure you could.
Good evening. Hi. Let me see if I can expand on that a little bit to help you understand. He's talking about proving something or not proving something. So let me ask you, can you prove that you didn't kill President Lincoln? I say you did it. Can you prove you didn't kill him? Give me some reasons why you didn't kill him. You weren't born then? You look young for your age. Got a birth certificate? I got one over here that says you're different age. Just paper and ink. It's important to understand, in my opinion, the rules of the game. You cannot prove anything. So what Brandon told you is you've got to put the burden of proof, or more formally called the onus probandi, upon the other party. But how do you do that? Just like he said, with the question. I say you did something. You conditionally accept upon proof of claim that I was born then. I say you kill him. I conditionally accept upon proof of claim. What are you doing? You're switching the onus probandi. If you accept the rule that you can prove nothing, because this comports with the scriptures. What are you doing when you're accusing or proving your brother's accuser? You did this, you did that. So if you understand rule 1, you can't prove anything, you're not going to try and prove it. So just accept that. Okay? So how do we prove something in court? There is proof, right? Proof does get another good definition for proof for me that I like is the perfection of evidence. Proof is defined as one of the definitions as the perfection of evidence. They put in an allegation. That's evidence. I got a declaration here. This guy says it's true. That is evidence. But when does it rise to proof? When you prove it, not when I prove it. How do you prove it? Well, you violate the law. You do not merit remedy. What did we say merit was? Quality, deserving reward. What was deserving? Have by conduct a claim to. Are we not in a claims court? Didn't he talk about, where's their claim? They don't have a claim. Claim, to demand or ask for as rightfully belonging or due to one. How can it rightfully belong until you've proved it up? You're not going to prove anything. The other party's going to prove it. They're going to come into court and argue. All Brandon's going to do is say, hey, I just got a question. You switch it, and that guy's going to jump right up there, and he's going to argue, or he's going to make a statement. Remember, we have 4 doors. Brandon calls it 3. I call it 4. It's the same thing. Straight acceptance, a conditional acceptance, silence, or argue. But what's argue? Isn't argue fighting? Is fighting arguing? Is arguing reasoning? Is reasoning to explain or justify? If you justify, you make a statement. So if A equals B and B equals C, A equals C. So if fighting is arguing, and arguing is reasoning, and reasoning is making a statement, then if you make a statement, you just start a fight. That's the law. This is all according to the scriptures. Silence. What did God tell us to do in Matthew 5:25? Brandon's told you, he just didn't tell you in the way the scripture said, but he told you what to do. Agree with thine adversary quickly. This is all scriptural. This commercial law is all in accord with the Bible. King James Version is which I like. Agree with thine adversary quickly. That's what God told you to do. He didn't mince words. Agree with your adversary. So a policeman says, I'm going to arrest you and take you in if you don't do this. What are you going to say? You're supposed to agree with me. I'm the police officer. I'm going to arrest your ass. Well, what are you going to say? Yes, okay? I'm proof I did something wrong. Now, in a sense, that's going to work. But how about something better? Agree with me. You bet, officer, arrest me for 1 million United States dollars. That's a counteroffer. How many of you wouldn't want to be arrested? Arrest me for 1 million United States dollars and 100,000 for every hour at the police station. You know, or 1 million United States dollars paid in advance. You can say, what's wrong with you? You want to do business? Of course. Who doesn't want to be arrested? Any of you use extra million? And of course, you'll have some courses about how to, that's a contract, how to enforce that contract. He's telling you, get into the spirit of the game. I'm serious. This is a game. This is life's game. When you start having fun is when you've gotten down to the meat of to the heart of the matter. What's the heart of the matter? You better comport with the scriptures. Agree with thine adversary quickly before he takes you before the judge. whilst thou art in the way with him, before he takes you to before the judge, who will turn you over to the officer, and you're going to do a little bit of vacationing. And you're going to get time to think about your sin. That's a fact. So the police officer wants to arrest you. It's all right. Please. Conditionally accept. Conditional acceptance is always a counteroffer. And the magic, what he just got done here, a counteroffer is defined as a statement by the offeree which has the legal effect of rejecting the offer. That's what I only know about it, the legal effect of rejecting the offer. I like that. We're in legal world. Substance, form is all legal stuff. That trust deed is a legal document. And like the facts are on the moon, doesn't matter. And why do you ask questions anyway? Why do you want to ask questions? I mean, we got to understand why you want to ask questions and why you don't want to answer questions with a statement or an argument or an explanation or anything else. We need the principles. Not only did God just simply tell you, agree with the adversary, but why do you not want to? Let's go to the dictionary, Webster's, and we could look up deposition or depose. They're very close together in the dictionary, but almost identical definitions. Removal from office or position of power, especially from a throne. So all you kings and queens on the land, next time you answer a question, know that you have been deposed, removed from your office. Now, if the police officer wants to ask me some questions, like a little example I gave you where my friend was up at Orange County outside sitting and a police car pulled up and a couple officers were doing their job. And they're good people. Rest assured, they're there to help you, sharpen you up. They're just looking for their cattle. You, come here. Why are you accosting me? I told you to get over here. There's another offer. It's all offer and acceptance, he told you. It's the game. It's just offer and acceptance. It just sounds like a threat or sounds like this, but it's an offer. I told you to get over here. May I see some identification? This car and this uniform is identification enough. Another offer. Third time. Ooh, that magic 3. Are you refusing to identify yourself, officer? Let me see. Give me another cow. You get over here. That cow jumped right up, went over, frisked him, asked some questions. You have to know what's going on, the fundamentals. That's why you don't answer questions but with a question. I teach my students, you never answer a question with a question. Then about a month later, I say, I got a new rule for you. You never answer a question but with a question until it's time to answer the question. They go, what? I said, you just need to learn the basics first. We take an example. I might be worried about police coming to the door, so somebody knocks at the door. Hello. A couple guys in suits, a 2020 news team. Oh, but this don't sound good, does it? Looks like we're going to be slaughtered in the paper. Gordon Hall. What's this regarding? I just confessed that I'm Gordon Hall through silence, but I put something up that vitiated what they're doing. What's this regarding? Brian Smith and Brandon Adams with the state lottery. Gordon Hall won $100 million. In that case, I'm Gordon Hall. Hi. I'm not joking. In that case, I'm Gordon Hall. You don't want to sit there and just throw, I conditionally accept to be Gordon Hall upon proof of bona fide claim. No. You're acting like I did when I went on this last vacation. I couldn't see the forest through the trees. All the judge wanted to know is I wanted to stand on my claim. He says, I suggest you get an attorney, Mr. Hall, before you hurt yourself. I said, are you telling me I can't resolve the matter without an attorney having public benefits? He says, no. Did he, remove himself from office? No, it was time to answer the question. No, not at all. And then I didn't know what to say. And then he proceeded to go on. All I had to do, he made me an offer. Do you want an attorney? Well, I'd love to have an attorney if there was a controversy, if the record and pleadings of the parties before the court hadn't sat off, settled, and closed the matter, he's got to go, what papers? Well, then he's going to bring my claim back up. I'm making a claim. Otherwise, I was just, like Brandon told you, get on the subject. It's really good. So we got to get you where you're understanding the underlying principles, why you don't answer questions. Like he said, don't look for rote answers. That's what I had 11 pages Jack Smith and I put together. Well, I was fishing through my notes, and he knew I didn't know what I was talking about. I couldn't see the forest through the trees. All I had to do was just relax a little. Everything should have been just back to the claim. I had settled with the paperwork. But again, that doesn't matter. We're going to come in and see whether I merit a reward, whether I have by conduct a claim to. And what did God say? Agree. If I do anything but be honorable and humble and less than that, I don't merit a reward. I don't have by conduct a claim to. And I needed that public witness. But it goes on and on. So as you listen to what Brandon tells you, ease up a little on yourselves. We've just got to get you where you have some of the underlying principles and fundamentals. Why you don't want to answer questions. I don't want to be deposed. That's why. I don't want to be removed from my status as sovereign. Because all of you are sovereign, period. Most of you don't act sovereign, that's all. Everybody's sovereign. Everybody's equal. We know that. But not everybody acts equal. That's the difference. We've got to get you to know who you are, who you aren't, who they are, and what the game is. The game is just a game. So I'll turn it back over to Brandon. Go forward some more.
Okay, any questions pertaining to this particular subject or anything, any ideas, or anyone want to philosophize with me for a couple minutes? Oh, nice, Celine. Remember to turn it on.
Is there any possibility that I, in fact, may have done something wrong and I'm being caught or something? I don't know. Is there any such a thing? Or
Is there any possibility that you've done something wrong?
yeah, that for someone to have.
Are you fishing for allegations? Yeah, are you saying if someone makes a claim, is it possible that you're... I don't know, is it? If somebody says, hey, you stepped on my foot, and you know you stepped on their foot, what are you going to do? Oh, I accept that condition upon proof of claim. It's about agreement. You're right. I did step on your foot. I'm sorry. I apologize. Is there anything I can do to make up for it? Isn't that a counteroffer? He made an offer. You stepped on my foot. I said, okay. I accept that. Is there something I can do to make it right? Pay me $1 million. I don't have $1 million. Is there something else I can do? You see? Offer, counteroffer, offer, counteroffer. Don't fight or argue, but look to bring some kind of resolution. Always be, it's not personal. Like I said, it's never personal. And you could always just, if your heart's in the right place, it'll come naturally. Like, it's funny, the more I do this, the more I ingrain this into my being, it's happening in my dreams. Like, people try to come and create a controversy with me in my dreams. I mean, I used to have dreams where I would just throw someone to the ground and start beating the shit out of them. You know what I mean? It doesn't happen like that anymore. Like, I go automatically into, how can I bring a resolution? Or accepting their position in my dreams. Like, I mean, I can fly, but I got to go into being a creditor when it comes to a controversy. So it's something that takes a lot of practice. I will be the first to admit I am not perfect. Well, I am whole and complete, but I am not flawless. And I do occasionally catch myself taking something personal.
It's a tendency that we have also to believe that we can be accused of something, or that there's such a thing. When you're saying, based on what you're saying, there's no such a thing.
Yeah, she's soft-spoken.
And I just got out of the course that Brandon was recommending, and you're making it a win-win situation for both parties. And I'm just listening to what you're saying. I'm breathing, and it's just like my shoulders are relaxing. Everything is just like it's just a peaceful way of being. It's a very high road.
There you go. Creating a win-win situation is a good analogy. You know, that's why we're what? We're honoring their position. By doing a conditional acceptance, you're honoring their position. Like, hey, I'm not going to argue with you. I'm not going to fight with you. I honor you. I honor your position. However, this is what I'm going to need in order to bring a remedy. Or in order to give you your remedy. Because aren't they coming to you for the remedy? Why are they here? Why did you come? Why are you here for me? You must be looking for a remedy. Well, I'm here to offer you one. But I'm going to need a couple things.
The whole world is geared towards a winner and a loser.
Yes, yeah. Everyone always thinks there has to be a winner and a loser, just like you want to be right because they're wrong, right? You always create the polarities. Whereas what we've been talking about is in being a creditor, not taking a position, coming from the question, which doesn't create right or wrong. Remember, why did Adam and Eve get kicked out of the non-commercial zone? Because of knowledge of good and evil. They created right and wrong. They started judging. That's what creates debt, right and wrong. Sin, virtue. Okay, you're making it up. You're judging. So if you get encountered and you automatically judge, they're wrong. I'm right. You've created a debt.
Creditor-debtor.
Right, you've created a creditor-debtor relationship. And then you argue. So then you go from being the creditor to the debtor.
It's not a win-win situation.
It's not a win-win situation at all. In fact, most of the time, I've even heard people say this. Like couples who are getting divorced. I'd rather no one get the money than her get it. Or I'd rather torch the car than give it to her. I'd rather burn down the house than give it to her. This guy's so in a lose-lose mentality. Win-win is outside of his scope of reality. It doesn't exist. He sees it as, she's winning, I'm going to lose, so I'm going to create a lose-lose. Because screw her. I ain't going to let her win, right?
So as creditor, we are agents of peace.
Yes. It's funny. I look at creditor as I don't look at the word creditor like a bank calls themselves a creditor. I look at creditor as creator, as virtuous. That's what I consider a creditor. See, debt, debtor, sin, that belongs on one side of the spectrum. Creditor, creator, virtue belongs on the other side of the spectrum. Is one right and the other wrong? No. I'm not going to make up any judgments about it. I'm not going to judge this one against this one. I'm not going to weigh this one against this one. I'm just saying I want to live over here in virtue and in creation, because creation is empowering. I can create. I'm responsible. I'm not a victim. See, over here on the debt side, I'm a victim. A victim to the world around me. A victim to the people around me. 3 minutes? All right, we'll go to break in about 3 minutes.
Thank you.
Very welcome.
Brandon?
Oh, you got it?
On this issue of sovereignty, for what it may be worth, there are two very important cases. And then in California, there's the government code, which I pulled off of Bill Thompson's work. The first case from the late the 1790s was 1 John 4 that says the people of America now have the sovereignty of the prior king of England. You then come forward to 1898, and it's Yickwo versus Hopkins, which is, I believe, 118 U.S., and I don't know the case number. And then the California government code, sections 11120 and 549.
Do those codes have authority over you?
No, they say that you are the sovereign and the agencies of government behold to you, not you to them.
I get that. What I'm saying is, what does it have to do with you?
It fortifies your position as
Do I need proof?
Well, if they try to ask for it,
I'd ask them a question. I'm not here to prove my position. I get what you're saying. I get what you're saying. And you're like Gordon, you're like a walking dictionary. And I love that about you. Because I can't do it. I can't just spit things out of my head and memorize codes and sections. But do you need that when you're always going to be flipping around the burden of proof on the other party? Prove I'm not sovereign. Right? I don't care what your government code says. I don't care what your statutes say. I don't care what any of that says. Okay, we got to break for the tape. Okay, I guess we'll take the break now since we got started so late, and I don't want to go too much later. So let's reconvene back here at 9 o'clock.